Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Min Kim from our Edison, New Jersey office. Hi there, Min, and welcome.
Hi, Ariana. Nice seeing you again.
Thank you so much for coming back. For today's topic, we will be talking about the new H-1B Modernization Rule set to take effect on January 17th, 2025. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. If you have questions, please comment them below or email us anytime at info@chug.com. Okay, Min, I know we have a lot to cover in terms of the new H-1B modernization rule that's going into effect tomorrow, so I don't want to waste too much time. But Min, if memory serves me right, I believe that today's live is a follow-up from a live that we hosted way back in April. I believe that around that time, news started trending that this proposal for a rule change was actually making some progress. And here we are on the eve of President-elect Trump about to be sworn into office, and this new H-1B rule is now upon us.
Yeah, that's correct, Ariana. We did do a live. I remember discussing the finer points of the new H-1B modernization rule when it was in draft form and subject to revision. After going through the notice and comment period. But now we know what the new rule officially looks like, and frankly speaking, it's not too different from what was originally planned by the government.
Yeah, so okay, let's just start then by summarizing the most important takeaways from the rule. What should our audience be aware of?
Well, I believe the main takeaway of the new H-1B rule is that it's like a combination of the agency reaffirming previously followed government practices, also clarifying certain unclear policies or things that were subject to different types of interpretation, but also the government doing a hard pivot of sorts from the trends that they might have followed before and which stakeholders might have relied on earlier. The rule has a lot to it, but probably the most immediate urgent takeaway is that the new I-129 form will be required effective tomorrow, January 17th. USCIS was earlier asked whether a grace period of sorts can be afforded to stakeholders, employers, law firms, and perhaps using the earlier edition of the I-129 form. And the agency, in rather clear terms, said no. So, as of Friday, January 17th, any non-immigrant petition for a foreign worker seeking a visa classification must use and file the new edition Form I-129, edition date 1/17/2025. And this, applies to other visa categories as well, L1 cases, O, TN, E, and so on. If USCIS happens to receive an I-129 H-1B or L or TN case tomorrow using the previous edition of the 129 form, that petition will be rejected and returned back to the petitioning employer for failure to use the correct edition form.
Wow, no grace period. So the stakes are definitely high then, not just for H-1B employers, but for all employees, employers seeking to file a visa petition for a temporary foreign worker. And considering that most of these cases are couriered to USCIS via overnight delivery, it does appear to me that for any company out there right now who's working on such a case and plans to ship that case via overnight courier to USCIS today, that case should use the new edition I-29 form, right?
Yeah, absolutely. I would agree with that. Otherwise, it will likely be kicked back.
Okay, so let's talk about the rule itself and what changes we can expect in the H-1B visa program.
Probably, I would say the most impactful change that will have the broadest effect, I believe, is how the new H-1B modernization rule seeks to change the definition of specialty occupation. As most know, an H-1B visa petition can only be approved if USCIS is convinced that the position being filed by a US company for that foreign national worker qualifies as something called a specialty occupation, or basically a professional worker whose duties more or less require the attainment of a bachelor's degree in a related academic field. Now, that's been the rule for decades, but the blueprint USCIS uses in getting to that conclusion whether such a position qualifies under that definition, it's sort of evolved over the years. In some years, the agency has had a rather lenient approach. So, for example, as long as an employer is not saying that its software developer position requires an art history major, for instance, in order to be hired into the role, the agency would have found that the specialty occupation definition has been met. But in other years, where it's been a little bit more restrictionist, that same definition has been tightened up. Perhaps USCIS found that the prevailing wage associated with the role is too low, level one wage, for example. And by some form of, government reverse engineering, USCIS concluded that a professional worker cannot command, just a level one wage, and therefore the position cannot rise to specialty occupation levels. Another example is the agency perhaps finding that the position offered is not narrow or precise enough in terms of the type of education required. So if a software developer role, using the earlier example, happens to require a computer science degree, but it also may accept an electronics engineering degree as well. The question is, are those two academic fields sufficiently related to one another? In USCIS's determination, if they are not, then the definition of specialty occupation is not met. Now, for this rule, this H-1B Modernization Rule, it appears there are two main takeaways in how I read the rule, and how USCIS is looking to define, or some might argue redefine, the definition of specialty occupation. One, the rule clarifies that an occupation that normally requires a bachelor's degree doesn't mean that it must always require a bachelor's degree. And two, that same position can qualify as an H-1B specialty occupation, even if the employer accepts a range of different degree fields, so long as each one of those academic fields is directly related to the duties of the H-1B position.
Okay, I want to stop you there, man. So you're telling us that this new H-1B modernization rule, something that we've been waiting months to be released, is essentially saying that the word normal doesn't equate to always. And an H-1B role at a company can have a list of different academic degree fields. I've always understood that the H-1B definition included these 2 points already.
Right, right. In many ways, that's correct. You got to remember though, this new rule, in addition to introducing some changes to previous government policies, as I mentioned earlier, it simply seeks to clarify, previous guidance that was in existence earlier since the beginning of the H-1B program. I would say this redefining of the H-1B definition kind of falls within that bucket. But just because it might be more of a clarification than something entirely different, this isn't necessarily a bad thing, in my opinion. Actually, when the rule was in draft form, just to give you an example, and released to the public for review many months back, the rule expressly named certain academic degrees like business administration or a general liberal arts degree as the types of degrees that wouldn't meet the specialty occupation definition. Now, if those changes that were earlier mentioned in kind of naming those general degrees, if they made it into this final rule, then I would consider that to be a rather large change. The kind of change that you were referring to earlier. But I believe a change for the worse. There are plenty of colleges and universities, worldwide, and here even in the U.S., that offer a general liberal arts education, and oftentimes, such broad exposure to a wide range of academic disciplines is precisely what might prepare a candidate for an entry-level job, at an H-1B employer. But if Homeland Security had its way from the beginning and published a final rule that had this original language of eliminating general degrees like a bachelor's degree in business administration, for example, then a rather large section of available jobs at different hiring employers might have been pushed out, as the H-1B visa option would no longer apply. So, change is not always a good thing. I suppose that's what I'm getting at.
Okay, fair point. So are you conclusively saying then that if a job is posted by an H-1B employer and that employer is willing to accept a general business administration degree and finds a foreign national candidate with such a degree, then the H-1B petition to be filed will be approved, at least according to this new rule?
Not quite. I wouldn't go to that extent. I wouldn't say it's approval across the board with no exceptions. But the analysis in kind of making that determination will be more nuanced, which I believe it should be. Rather than USCIS seeing that this foreign national worker has a business administration degree only and concluding, oh, that's too general and too broad to qualify as a specialty occupation, the USCIS officer will hopefully leave room for the petitioning employer, the petitioning H-1B employer, to kind of point out what about the bachelor's degree coursework involved in a foreign national attaining that business administration general degree. What about that coursework was relevant in him or her being considered qualified for this specialty occupation role? So, essentially it's a deeper dive because not all business administration degrees or liberal arts programs out there are created the same.
That's a good point. And I do agree that for something as complex and involved as defining specialty occupation, having nuance and getting to that definition is the better approach. Okay, so perhaps more things have remained the same in terms of defining an H-1B specialty occupation than any changes. What's your overall take on the published rule, though? Is it better than what businesses and foreign nationals had before? Is it worse? Or perhaps it really is just neutral?
Um, in the end, I do think it's better. We're in a better place, and there are more pros than cons, especially as it pertains to USCIS clarifying its interpretation that, normally requiring attainment of a qualifying bachelor's degree does not always mean always require. I acknowledge, the point that this might be considered a little trivial, kind of trying to parse out what it means to be normally required versus always required. But in the H-1B analysis, it really is a big deal because before, when USCIS was adjudicating such H-1B petitions, the agency at times heavily leaned into this issue and even used statistics posted by the Labor Department to justify denials of those same H-1B cases.
Denials of H-1B cases based on normally versus always. Can you explain what you mean?
Right, right. So, I mean, there are published Labor Department studies out there, and they're publicly available online. Those same studies they often show that let's say 40% or 60% or whatever other percentage amount of such jobs are held by bachelor's degree holders, depending on what type of job it is and in what industry. Now, let's say we have a software developer occupation, and an associated Labor Department study might reveal that 85% of such developer roles are held by bachelor's degree earners. So kind of, using these numbers, you would think that such a data point will work in favor of the argument that the role of software developer requires a bachelor's degree and therefore qualifies as a specialty occupation for H-1B purposes. But I suppose from USCIS's standpoint, 85% holding bachelor's degrees means that 15% do not, which is, for better or worse, used by USCIS at times in concluding that the bar of specialty occupation was not met. Now, thankfully, in recent years, the courts have gotten involved with this issue and pretty much forced USCIS to walk back from this hard stance. But now we have a final rule in this H-1B modernization rule, which expressly states that in rather plain terms, that such instances should normally require a bachelor's degree, therefore qualifying for H-1B visa classification. This, in theory, should produce more consistent results, in my opinion, and adjudication at USCIS. Just because not every software developer or civil engineer or linguist or what have you requires a bachelor's degree, and so, it doesn't license USCIS in denying the H-1B case. So that's what this rule attempts to achieve.
I must say that it's rather astounding to hear that the government attempted to argue that the word normal meant always. It's a bit absurd if you think about it, but I'm glad to hear that this new rule puts an end to that argument. What else about the new rule? You briefly mentioned that the rule requires proof that the academic degree required must be directly related to the job duties, especially in situations involving a range of academic degree fields. Can you expand on that a bit?
Absolutely. Once again, at least for me in my practice, this is just a codification of what I understood the definition of specialty occupation to be in the first place. When filing an H-1B petition with USCIS, for example, just naming a degree like computer science, it really is not helpful to USCIS, especially if that named degree is one of many different degree fields that are listed. USCIS instead of just naming a degree, they want to know what about attaining the computer science or the engineering degree was instrumental in being able to perform the job duties involved. Now, for certain occupations, this is obvious. A CS degree, a computer science degree, prepares one to become a software engineer, for instance. A civil engineering degree helps one to become a civil engineer. But for most occupations and degree fields, it's less obvious. So for those less obvious examples, it's the burden of an H-1B employer to tie and make that logical connection, using those same words that the government use in kind of, issuing this final rule, in making that logical connection between the academic degree involved, as well as the underlying coursework that led to the attainment of that degree to the H-1B position's very own set of job duties. And this will, especially apply when an H-1B position happens to require a range of different acceptable degree fields. Before, USCIS typically viewed such petitions less favorably and more or less concluded that because a relatively large number of different academic degrees were acceptable for the H-1B role, this in turn would disprove that the position at the employer qualified as specialized or rose to the level of a specialty occupation. Essentially, the agency was equating specialty occupation to narrowness and contending that a role that accepts a degree in A, B, C, and D, and so on and so forth, on its face, it cannot qualify as a specialty occupation for H-1B purposes. So this new rule pretty much says the opposite, but with the huge caveat that the burden remains with the employer to prove that a degree in so-and-so and this is closely related enough and has that logical connection with the position's overall job duties.
Hold on, I want to stop you again, Min. Isn't that obvious? Why wouldn't a hiring company, an H-1B employer, want every degree field it lists that has that logical connection with the open position's job duties?
I'm not disagreeing with you, Ariana. Yeah, I can definitely see the merits, in that argument. That's and why USCIS will certainly use that approach in that way. But in reality, when any hiring employer looks to the labor market for qualified new hires, that company typically seeks to cast as wide of a net as possible in order to attract as many potentially qualified candidates as it can. But now with this new H-1B modernization rule, in an effort to cast that wide net, if an employer lists, let's say civil engineering or computer engineering and so on as part of its typical recruiting efforts in looking to hire for similar roles, when that employer seeks to file an H-1B petition for a foreign national, the rule now compels that same employer to explain what about the civil engineering degree is logically connected to the position's job duties. What about a computer engineering degree is logically connected? What about other engineering degrees? How are they logically connected, and so forth? Essentially, it's a larger burden to carry.
I see what you mean. So it's more work, more proof. So would you say that this might be one of the larger cons to the new rule?
I would say so. It's reassuring to know that USCIS is willing to accept an H-1B petition where the position now involves different academic disciplines to be acceptable for hire. So it's not a flat out rejection on the part of USCIS if the agency sees an H-1B petition with a wide range of acceptable academic fields. With that, USCIS still fully expects that you as the H-1B employer explain how every one of those fields of study is related to the set of job duties being proposed for the foreign national that the employer seeks to hire or retain.
Okay, let's move on to other aspects of the new rule. To be honest, we probably have to do a part two of this Thursday live to really unpack everything this rule seeks to achieve, but we'll try to get to as much as we can now. What's another main takeaway from the new H-1B modernization rule?
I would say probably right behind the specialty occupation issue in terms of importance is how USCIS is looking to de-emphasize the need to prove employer-employee relationship between the petitioning H-1B company and the foreign worker for hire. Instead, USCIS seems to focus on the H-1B employer proving that a bona fide job offer exists.
Bona fide job offer, what do you mean by that, and how is that different from proving the existence of an employer-employee relationship?
Well, before, there typically was a need to prove that an employer-employee relationship between the H-1B company and the foreign national worker existed, and how the company held some element of control over the employee in the way the intended job duties were performed. Controlling the worker and thus proving that an employer-employee relationship was in fact formed was also proven by how the company retained the ability to hire, fire, evaluate, and appraise the worker, as well as pay the worker and provide certain employee benefits. Now, apparently that requirement of proving these things to USCIS has been eliminated and replaced with a focus in establishing the existence of a bona fide job offer in a specialty occupation as of the requested start date.
Okay, so how do H-1B employers do that then? Prove the existence of a bona fide job offer?
Essentially, there should be sufficient H-1B work available for the foreign national to immediately start doing. Now, this has always been the requirement, so don't get me wrong here. The focus on bona fide job offer, it isn't a new creation on the part of Homeland Security and kind of publishing this new H-1B modernization rule. It's always been out there, but perhaps the focus on it hasn't been as critical as establishing that an employer-employee relationship was in existence. But now it appears that USCIS is definitely turning their attention to this issue once more, especially in light of the new different work arrangements that are now rather commonplace in today's marketplace.
Work arrangements? What do you mean by that?
Well, different work arrangements like telecommuting and working from home, being able to remotely work from any location provided you have a good Wi-Fi connection, working off-site at a end client customer location for so many number of days. With technology being what it is and the labor force still trying to adapt in current conditions and as we move further away from how things were during COVID. It seems like one thing that has indeed, sort of modernized as per this H-1B, modernization rule is USCIS finally coming around to understand and accept that employment relationship, which didn't exist 30, 40 years ago, like people being able to work from home, an entire state away or on the other side of the country, those employment relationships are now rather commonplace in today's workforce. But with this acceptance on the part of USCIS that work today in 2025, looks far different than what it did in 1985, for instance. It comes with the burden to further prove that if indeed actually an H-1B specialty occupation work is being offered to the foreign national worker, and that's where this bona fide job offer component kind of comes into play.
Okay, I follow you. But you're saying then that employers can't just prove that a bona fide job offer exists by issuing a job offer letter. I mean, isn't that what companies do? They're looking to hire, they find talent, they seek to onboard by issuing a formal job offer letter. It seems e easy enough for me, but I assume how it plays out at USCIS is far different.
Yeah. Your intuition is really spot on there. It does play out differently with the government because the government wants proof. At the end of the day, it's about proving the specialty occupation work is available. They want proof that more likely than not there will be work available for the foreign national new hire once he or she is onboarded at that H-1B company. Like any business can type up a job offer on Word and hand it to a prospective employee. What is one step beyond that is stipulating what kind of work, what kind of project that employee is expected to perform on day one and beyond that. And also, explaining how long has the H-1B employer been in business? Because one would assume that if a company has been in business 30, 40, 50 years, then more likely than not, it will continue to be in business and thus have available work for the employee to continue to keep himself busy for the requested 3 years of H-1B approval. So it's not like the business would go under and therefore the employee would be out of a job, violating the terms of his or her H-1B status and remain unaccounted for. USCIS looks to the long history of successful business activity on the part of the H-1B company and figures that this trend will continue to supply the H-1B beneficiary with sufficient work, and thus the requirement of a bona fide job offer will be met.
I see. So in a way, it's attempting to prove this bona fide job offer issue from two different ends. In one way, it's sort of looking forward. The company provides information of the intended project, the intended specialty occupation work that it plans for the foreign worker to start on day one forward. I would imagine greater specificity is preferred then, not so USCIS will be persuaded in knowing that the company has a plan, a bona fide job offer, you can even say, of bringing this individual on board. But also you can look at it from the reverse, not looking forward, but also looking at the history of how established is the H-1B employer. Have they historically been active in terms of operations, sales, generating revenue, and just growing overall? If the past indicators can lead to an expectation of future performance, then it's likely that those activities will continue and there will be sufficient work available for the H-1B beneficiary. And that's why a bona fide job offer is being issued for that beneficiary to perform that work.
Yeah, that's very impressive. I couldn't have said it better myself, Ariana. Past indicators leading to an expectation of future performance. That's exactly right, and that also applies in terms of revenue and profits, as you were saying. Even if a company is not decades old but is relatively new, a startup even. If that relative new companies, if their financials are sound, it's making money, or perhaps it really is, even a pure startup, but has commitment from investors and or customers and a business plan in place to launch it, then those are positive affirming factors that a company can point to in showing USCIS that it is indeed a legitimate business. It has available work for the H-1B beneficiary to start completing, and thus it's justified in its bona fide job offer to that same H-1B beneficiary.
Okay, so it seems like we have a handle on this bona fide job offer issue and how it's more than just a job offer letter. Is there anything else you want to add in helping to prove a bona fide job exists?
Perhaps one thing to add, though, is the changes involved when we are talking about when an H-1B employer assigns its employees to work off-site at a third-party location of its end clients. This often might be the case for consulting businesses, which have contracts with their clients, and pursuant to the terms of those contracts, the employer sends its employees to work at the facility of that end client. In those situations, this new H-1B rule, it now says in rather plain terms that contracts, statements of work, client letters that confirm such bona fide job offers at these third-party work locations, all that documentation will not be required.
But wasn't that always the case, Min? Consulting companies whose business model perhaps had a majority of their workforce deployed to work at the facilities of end client customers, these companies often were required to supply MSAs, SOWs, end client letters to prove the existence of such a service agreement with the petitioning H-1B employer.
Right, right. You're right about that. That often has been the standard and the general operating practice here in the industry. But because the H-1B regulation itself did not require such evidence per se, but those expectations on the part of USCIS were imposed by, let's say, policy memos and other secondary guidance out there that describe the standard operating practice at USCIS at that particular time. Those expectations, they can sort of be walked back by USCIS or re-implemented, at the agency's choosing. And oftentimes those occurrences, it depended on what president was sitting in office at that time. Regulations, in contrast, they're not the same as policy memos, and regulations by their nature have a more long-term and fixed impact to them. So even though many H-1B petitions filed by consulting companies have continued to include contracts, work orders, end client letters, and similar evidence to confirm that the H-1B employee is to be assigned to work at end client company, XYZ, for example, from this day to that day, and performing this set of specialty occupation duties as part of this project that XYZ, client company has agreed with our H-1B petitioning company. Now, this is the hard and fast rule across the board when it comes to confirming that a job offer, a bona fide job offer exists and will continue to exist when work is performed at a third-party work location.
I follow you. So even though it's been a long-standing practice of USCIS to expect that the contracts and other documents that speak to third-party work placement, it wasn't found in the actual H-1B regulations, and perhaps because of that, there were times when this wasn't enforced as much, especially during times when an administration was really pro-business and pro-immigration. But now with it being an official rule, it is the standard. But staying on the topic of consulting companies and H-1B employees being assigned to work at third-party and client sites, has everything just remained the same? Are there any changes proposed by the new H-1B modernization rule?
There are some changes, and a lot of the changes are rather dramatic. One thing for our audience to know is that the earlier requirement of an itinerary, it's been eliminated. In other words, an H-1B employer is no longer required to submit specific day-to-day assignments or work activities of what their H-1B employee would do at the third-party and client site for the full validity period requested. So instead, employers can just demonstrate that the position will exist by a certain start date, and the work order or client letter, the end client letter, should help improving that start date. And also another important change for consulting companies that rely on this business model of sending their employees to work at the location of their clients. If USCIS determines a beneficiary is quote unquote staffed to a third party, rather than simply looking at the job requirements for the H-1B position at the H-1B employer, USCIS will instead would do a deep dive into the job requirements for such roles at the third-party end client customer in assessing whether the position actually does qualify for specialty occupation status.
Hold on, I need to stop you there. Why would it matter that end client XYZ requires so and so for it for software developers? For example, when the H-1B employer requires a bachelor's degree, but essentially you're saying that it does matter, and perhaps that the only thing that does matter, what the end client has historically required for such positions and not what the H-1B employer has historically required?
That's correct, but only if the facts presented compels USCIS to conclude that it's a staffing arrangement on the part of the H-1B employer in its service contract with the end client XYZ in your example. According to the H-1B Modernization Rule, USCIS will make that distinction and conclude that a beneficiary is considered staffed to a third party end client by an H-1B staffing company if the H-1B employee fills a position within the third party's organizational hierarchy and aligns with the third party's overall requirements. But that same beneficiary, they will be considered as quote unquote providing services instead if he or she is working on a distinct project for the third party end client and does not integrate himself into that end client's overall operations. So essentially carving out the differences between a staffing company versus a consulting company and treating the two companies different for H-1B purposes.
There's a lot to unpack there, Min. If you're available next week, maybe we can do a part 2 of this Thursday live in further exploring that issue and differences between a staffing company versus a consulting company, because it seems that the entire H-1B program might hinge on those critical differences, especially for those companies that rely on this business model of assigning their workers to end client sites. Are you available next week to continue this conversation, as I really don't want to rush it?
Yeah, Ariana, I'm available. I think it's a good idea to dive into this issue next week and really kind of give it the time it deserves. As well as touch on other things about the new rule that we unfortunately didn't get to today.
Thank you so much, Min. We really appreciate it. I know you're really busy, so thank you for taking the time to come and share your insights and cover this important topic with us. If you guys have any questions, please email us at info@chuk.com. We can cover them next week. That is all we have time for today, so this brings us to the end of our conversation. Thank you, Min, for joining us. Thank you, everyone, for tuning in today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, email us anytime at info@chuk.com, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you again, everyone, for joining us. Thank you, Min.
Thank you, Ariana. See you next week.
Thank you. Have a great day, everyone.